Okay, good afternoon, everybody. If you could just find your seats, we're going to get started here in just a few seconds. All right, well, thank you all for being here. And again, good afternoon. My name is Jesse Panuccio. I am a member of the Litigation Practice Group Executive Committee. Pleased to welcome you to this breakout panel entitled The Judiciary's Federalist Revival. My job in kicking off this panel is just to make a few brief, mostly logistical remarks. First, this panel is coordinated by the Federalist Society's Litigation Practice Group. The Society's practice groups, the executive leadership, and those that staff it within the Federalist Society are chiefly responsible for all the breakout sessions during this great conference. The practice groups also coordinate other excellent programming throughout the year, including the Federalist Society's teleforums, its executive branch review conference, and lunch panels throughout the year. So we would encourage you to keep track of all of that. If you're interested in the practice groups, they cover just about every area of practice in law. And if you wanted to serve on an executive committee, we would encourage you to reach out to the Society and get involved. And finally, we want to thank those involved in the practice groups for putting these panels together at the conference. Second, let me just provide a reminder that to qualify for CLE credits, you must sign in and out once per day using the CLE QR code, which is posted in your program and throughout the lobby and the area here. You need to do that once a day to check in, once a day after the last panel to check out in order to get credit. Third, an announcement about this evening. The banquet tonight, the dinner tonight, is not at Union Station this year. It is at the Washington Hilton. If you've gone to Union Station, you are going to be having a different dinner. So make sure if you want to get to the dinner, beginning at 5:15, there are shuttle buses to the Washington Hilton. They will leave the Mayflower lobby here every 5 minutes. Pickup is on in the back entrance, and the last bus will leave at 6:30 near the gift shop. Pickup is near the gift shop. Finally, it is my privilege and honor to introduce our moderator for this afternoon's panel, the Honorable Carlos T. Bea. Judge Bea serves on the U.S. Court of Appeals for the Ninth Circuit, to which he was appointed in 2003 by President George W. Bush. Judge Bea is a graduate of Stanford University and Stanford Law School. He began his legal career in private practice in San Francisco, principally in the area of civil trials, both jury and non-jury. He taught courses in civil litigation advocacy at Hastings College of Law and Stanford Law School before beginning his judicial service as a judge of the San Francisco Superior Court. Judge Bea, thank you for sharing your time and your expertise with us today. The floor is yours.
Thank you very much, Jesse, for that nice introduction. And we'll get started on this panel. Recent cases from the Supreme Court have indicated a trend to send cases back to courts for application of state constitutional and statutory law. It's been called in this panel the Federalist Revival. For those of us who attended the session down in Arizona in 2020 regarding the Federalist Papers, the distribution of power to the states sounds to me more like an anti-federalist than a federalist idea. But anyway, that's the subject of today's presentation. I will introduce, first of all, each of the panelists, and then they'll make their opening remarks in the usual form. And then we'll take a few minutes to discuss a case that I got back last year from the Supreme Court telling me to apply California choice of law rules, and you might be interested in. And then we'll have a period of discussion among the panelists, questions regarding the practice of remanding for application of state laws. So then the question is, we'll finally come around to the idea to asking the question, why is the Supreme Court doing this? Why is the Supreme Court getting interested in application of state law? Besides having read Jeff Sutton's book, why are they doing this? So we'll start now with introductions. On my immediate left is Justice Evan Young, who is a justice of the Supreme Court of Texas. He was appointed by Governor Abbott in 2021 and was elected to a full term the following year. Justice Young is a former clerk of both Harvey Wilkinson and Antonin Scalia, and served as counsel for the Attorney General in the U.S. Department of Justice, and did a stint in Iraq in 2007 and 2008 at the embassy there. He went into private practice and worked for Baker Botts, and is the chair of the firm's Supreme Court and Continental Practice Group. That's Evan Young. Immediately to his left is the Honorable Rebecca Bradley, who's a justice on the Wisconsin Supreme Court. She was elected in 2016 after being appointed by Governor Scott Walker in 2015. And before joining the Supreme Court, she served as a District Court of Appeals judge and a county trial judge, circuit court judge, and worked as an attorney in private practice. To her left is, and I'm not trying to indicate political positions by saying that, is the Honorable David Wecht, Justice of the Supreme Court of Pennsylvania. Judge Wecht joined the court after his election in November of 2015. Prior to joining the Supreme Court, he served as a judge of the Superior Court and of the Court of Common Pleas in Pennsylvania's 5th Judicial District. And he's the author of one of the cases that he probably will be discussing, which has to do with the financing of public schools based on state and local financing. Judge Wecht was twice elected to the Allegheny County Registrar of Wills and Clerks Court in Orphans Court. So with that, we'll get started, and I'll ask for opening remarks from Evan Young.
Well, I am delighted to be here, and my being here, any of the three of us, not Judge Bay, any of the three of us is statistically improbable, in fact, and I say that because there are 172 active U.S. Circuit judges. There are 7 vacancies, it looks like. Of those 172, 22 of them are on panels at this year's National Lawyers Convention, 13% of the total. And there are at least a couple of senior judges, a couple of district judges, a couple of other federal judges, so 28 federal judges. Of the 330 state Supreme Court justices in the United States, there are 4. 3 of us and Justice Mitchell, who was on a panel a little bit earlier. And why is that relevant? Why is the 1% of the Supreme Court, 13% of the circuit judges, why is that relevant? Well, it's because that ratio is actually an improvement for the state courts. State Supreme Courts have been something of a backwater, maybe in real life, but certainly at Federalist Society National Lawyers Conventions, as the dozens of federal judges every year really put the federal in Federalist Society. The reason for the state Supreme Court seeming like backwaters was that for a long, long time, most of the highest stakes litigation, especially of constitutional magnitude, was in federal court, and often about federal constitutional law, too. When I went to law school, I had a professor, some of you may have had him as well, Professor Ellickson, property law scholar, and he diagnosed what he called the Yale Law School disease. And that disease was that even if you have to find a principle of state law, the way you do that is by finding some federal court that has said what state law is. And it can be a district court in a different state, that's okay, but you wouldn't want the Pennsylvania or the Wisconsin or the Texas Supreme Court. That's what the Yale Law School disease was, and it was a malady that resulted from, I think, in large part, the extreme federalization, constitutionalization of so many areas of our law. And so that meant that what state law was mattered an awful lot less in an awful lot of very important cases. Now, I'm not trying to overstate that. Well, not overstate it too much. State law always mattered. Eerie guesses were always important. State law was what the federal courts would and still do apply when state law questions are determinative. We'll talk about certification, I think, a little bit later, often in contract or insurance or tort law questions when there's diversity jurisdiction. But the very existence of this panel reflects that some of that is changing, at least in some areas, what state law is even if the bread and butter of state Supreme Court still typically is superintending the common law, construing statutes, regulations, making sure state government is working. The Supreme Court of the United States is edging, in some cases jumping perhaps, towards making state law play a much larger part of daily life of our citizens than it perhaps did in an awful lot of areas up until relatively recently. Of course, that's not just for state courts, it's states. We just saw a couple of days ago another example of the people of a state saying, fine, if that's not going to be federalized, then we will decide for ourselves what that will be. It's not just state courts, it's states now that really matter in terms of saying what the constitutional principles that govern our people will actually be. That's the first point that I want to make, that even if you don't necessarily accept the premise that states were sort of backwaters when it came to the great constitutional dialogues, at least maybe you could accept that they're becoming much less so now. And the second point is that a number of state courts, including mine, have not done all that much over our histories to explore the differences between our state constitutions and the federal Constitution. In part, why bother? If the federal Constitution is going to be so overpresent, omnipresent, and govern everything, there's not a whole lot to be gained in many instances, or so the theory was, from exploring the nuances of our state constitutions. And there are many kinds of constitutional provisions in state law where this matters. Sometimes the state provision might be more or less coterminous with federal law. And I'll take Texas, for example, I know it a little bit better. Our contracts clause in our Constitution reads almost identically to the federal contracts clause, and there's evidence that that was purposeful. But our takings clause does not read like the federal takings clause. It reads quite differently, and there's evidence that that was very purposeful as well. And there are other kinds of clauses. In Texas, we love juries. We love juries for everything in Texas, so much so that we have multiple provisions of our Constitution. In our Bill of Rights, there's a jury trial provision. Also in the Judiciary article of the Texas Constitution, there are other provisions guaranteeing the right to trial by jury. But historically, we've just said, well, it probably means the same thing, which can't really be right because they're written differently, they were added in different ways. But we're only now beginning to explore these questions. And then there are other kinds of provisions. We have the due course of the law of the land. We don't have a due process clause. A lot of states don't. Due course clause. What do all of those mean? Well, we don't know, because our tradition has largely been to say, it probably means what the federal Constitution means. Call the next case, and hopefully it's about insurance law or something. And there are two reasons, at least, for that. First, as I mentioned, why bother? Whatever we say the Texas Constitution meant, in many instances, the U.S. Constitution is going to trump. And then a second reason is even less salutary, and that is that we historically have gotten very little help from parties and lawyers in the bar, and this is starting to change. I wrote a concurring opinion that's in the materials called City of Baytown versus Schalk about our takings clause, and Justice Busman, of course, has written another opinion raising some of these points about our takings clause, which is that you might really have a good Texas takings claim, but if you just mouth the words Texas and federal constitutions, and then you only bring to our attention federal case law and federal doctrines, that isn't doing anything to help us figure out what the differences might actually be. And so my third point is that this is an increasingly urgent problem. It poses serious risks of us having a doctrinal deficit in this way, a gap that is there as the Supreme Court of the United States seems to be causing federal principles to recede. And that creates risks because when there is a gap, the temptation is to fill it, and perhaps to fill it unwisely, given the somewhat, not all states are like this, but in many, the remarkable level of undevelopment, or at least underdevelopment. And you mentioned Chief Judge Sutton's great books, which are wonderful, anticipating some of these problems and describing it. I think that the solution is not necessarily for Supreme Courts of the states to move into fifth gear and just say, all right, we're going to fill the gap immediately, because our job instead is to soberly undertake the very serious work of determining the original public meaning of our state constitutions. And my fourth point is that that is a very hard thing to do, much, much harder than it is compared to the federal Constitution. Not that that's easy, but our state constitutions often are much bulkier. Texas is second only to Alabama in our length. We have entire forms in the Constitution with blanks that would be used for home financing statements. We have provisions that describe the taxation of green coffee beans imported into particular ports in Harris County, or the creation of drainage districts in Ector County. We just had 13 new provisions of our Constitution added on Tuesday. The only one that the voters rejected was the one that would allow judges in our state to serve past the age 75. They nixed that one. And they almost nixed the provision that would have allowed Galveston County to abolish the position of county treasurer. The people really thought maybe they needed that county treasurer in Galveston County. But we have all of this complexity. It's constantly changing, and it's all so much less well-sourced than the federal Constitution is. And so it's much harder to really meaningfully, reliably, systematically figure out what the original public meaning is. And you add to that the dearth of precedent that would perhaps have arisen at the time or near the time when these provisions were enacted. And so we need help. We need help from the bar, from the government, from the academy to bring us good cases, to preserve state issues at all times in the litigation. We need amici to be entering the fray on both sides of these important issues. We need state government to be doing hard archival work, to be gathering the information so that our state constitutions can be meaningfully interpreted. And we need to make sure that even though the chips are going to fall where they're going to fall, that we don't let them fall until we know for sure what they mean. And that's my last point, that in any given case, regardless of what kind of those four kinds of texts that I mentioned, there are at least three options that we have to keep our eyes peeled for and open for, and that is that perhaps the state constitutional provision really does and purposefully meant just what the federal analog says. Or maybe it really does protect a lot more purposefully than the federal analog did, or maybe it protects a lot less. And all of those need to be options that we think hard about so that we can take this opportunity, recognizing it also as a risk, to make sure that our courts are doing their job when the U.S. Supreme Court is creating space for them to do it.
Thank you very much, Justice. Now, can we hear from what the problems Wisconsin has?
I need more than an hour and a half for that. Good afternoon, everyone. I'd like to thank the Federalist Society for the invitation to participate in this panel, and thank you, Judge Bea, for moderating it, and thank you, Justices Young and Wecht, for participating. The United States Supreme Court's renewed respect for federalism and state sovereignty is something to be celebrated, but there is good reason for caution. In Wisconsin, new federalism has a pejorative connotation. Under our state constitution, the people of Wisconsin gave the lawmaking power to the legislature. Nevertheless, nearly 20 years ago, Wisconsin suffered the dictates of an activist state Supreme Court that didn't hesitate to exceed the limits of its constitutional authority. This year, a state Supreme Court election shifted the balance of power from a majority philosophically committed to textualism, originalism, and respect for our structural constitution, to a new majority with a philosophy grounded in politics and policy, unrestrained by universally respected boundaries surrounding the exercise of judicial power. For Wisconsin, I predict the recent ascendance of federalism will embolden the wrong branch to resolve all the important policy questions reserved to the states or to the people. In 1948, Winston Churchill observed, "Those that fail to learn from history are doomed to repeat it." So I will briefly recount some relatively recent Wisconsin Supreme Court history. In 2004, then Justice Diane Sykes left the Wisconsin Supreme Court for the Seventh Circuit Court of Appeals. The governor appointed Justice Butler to the open seat, creating a liberal majority. As Judge Sykes described it during her Hallows lecture at Marquette University in 2006, the court's term following her departure was a watershed that marked a dramatic shift in the court's jurisprudence, departing from long-accepted principles that normally operate as constraints on the court's use of its power. I recommend reading Judge Sykes' remarks in full for an in-depth study of how an activist court can intrude on the prerogatives of the political branches for the purpose of imposing judicial policy preferences on people who previously rejected them through the democratic process. I'll give just a few examples of the court's willingness to manipulate the Wisconsin Constitution to justify its policymaking. In State v. Knapp, the defendant was suspected of killing a woman with a baseball bat. A police officer went to Knapp's apartment to arrest him and asked for the clothes he wore on the night of the murder. Knapp pointed to a bloody sweatshirt, which the officer seized after intentionally withholding Miranda warnings. He was charged with first-degree intentional homicide, and his attorney filed a suppression motion, which the trial court denied. The Wisconsin Supreme Court reversed, and the state appealed to the United States Supreme Court, which vacated the judgment and remanded the case back to the Wisconsin Supreme Court because its earlier decision was inconsistent with the newly decided U.S. v. Patain case. In that case, the court held that the failure to give Miranda warnings does not require suppression of the physical fruits of the suspect's unwarned but voluntary statements. On remand, the Wisconsin Supreme Court decided to, in its words, utilize the Wisconsin Constitution's analog to the Fifth Amendment to reach the same conclusion as its initial review had produced. Specifically, the Knapp II court held that the Wisconsin Constitution requires suppression of the physical evidence obtained as the direct result of the Miranda violation. The majority expressly embraced the new federalism movement in doing so. Now, I agree that state courts should not reflexively interpret state constitutional provisions in lockstep with their federal counterparts, and of course, state constitutions can afford greater protections to its citizens than the federal Constitution provides, but the Constitution itself must actually provide them. State courts do not have the authority to invent protections that are nowhere to be found in the Constitution as originally understood. The Knapp II court did mention a case decided shortly after statehood in which our court declared no person is compelled to give evidence against himself or to testify in any matter tending to criminate himself, but the Knapp II court did not even attempt any historical analysis to support its theory that somehow the violation of those rights means suppression is the remedy for their violation. Instead, that court relied heavily on its view that the officer's conduct was repugnant and required deterrence, and on the court's professed desire to preserve judicial integrity. However well-intentioned, judicial policy goals cannot alter the fixed meaning of the Constitution. Neither repugnant facts nor intolerable actions by law enforcement have anything to say about the meaning of the privilege against self-incrimination or the remedies for its violation. These were nothing more than justifications for the exercise of judicial will. Although a majority of my court may at times prefer certain constitutional protections for criminal suspects, it remains the prerogative of the people of the state of Wisconsin to bestow them. As a side note, even though the court in Knapp II acted beyond its constitutional authority, its holding was never overturned, despite a 15-year period during which judicial conservatives held a majority and had the opportunity to overturn it. For state courts, the laboratory of experimentation tends to ratchet the law in one direction, toward results generally favored by progressives. Why? Because judicial conservatives often apply the doctrine of stare decisis even in cases in which an earlier decision was objectively wrong. Judicial conservatives are also more likely to read provisions of state constitutions in lockstep with federal courts' interpretations of federal counterparts. Last year, my court decided a case in which a transgender defendant challenged the constitutionality of a statute prohibiting sex offenders from legally changing their names. She argued that the law violated the Eighth Amendment's prohibition on cruel and unusual punishment and the free speech clause of the First Amendment. After examining the original meaning of those constitutional provisions, we concluded that the statute did not offend them. 3 members of my court disagreed. They said, quote, "But times change, societies evolve. Instead of looking backward to esoteric sources to define the contours of modern existence, we should instead look, as we do in other contexts, to, quote, evolving standards of decency that mark the progress of a maturing society," end quote. Had that case been postured differently, a majority of the members of my court, as currently constituted, could very well utilize our state constitution's free speech clause to impose their personal notions of evolving standards of decency and reach the result that the First Amendment denied them. But they would have to disregard the text in order to do so. Now, if the people elect judges who all but promise to decide cases in accordance with their personal values, why should we be concerned? As one reporter asked me, isn't that democracy? Whatever one wishes to call it, having a handful of lawyers refashion the Constitution in accordance with their own personal values without the participation or the input of the people is an affront to democracy. Although it may be tempting for people to elect state court judges who will achieve policy outcomes they desire but are unobtainable from the democratic process, it is a dangerous electoral choice to relinquish the power that the people constitutionally retained for themselves. In his dissent in Obergefell, Justice Scalia said the practice of constitutional revision by an unelected committee of 9 robs the people of the most important liberty they asserted in the Declaration of Independence and won in the Revolution of 1776, the freedom to govern themselves. Justice Scalia also wrote, "A system of government that makes the people subordinate to a committee of 9 unelected lawyers does not deserve to be called a democracy." Even though Wisconsin elects its justices, it is not democracy to subordinate the people to a committee of 4 lawyers, regardless of how they are chosen. Justices are, after all, elected to exercise judicial power, not legislative, and judicial elections can never override the Constitution. Even if evolving societal mores could change the meaning of the Constitution, why should the personal policy preferences of a handful of judges prevail over everyone else's? Any student of jurisprudential history knows that judges are not reliable protectors of individual rights or liberty when they seek to replace the original meaning of the Constitution with their own notions of the way things ought to be. Only the Constitution, given a fixed meaning that changes only through amendment, can serve as a reliable bulwark of the rights and the liberty of the people. As we proceed in this new era of renewed federalism, we would do well to keep in mind Hamilton's warning in Federalist number 78. Liberty can have nothing to fear from the judiciary alone, but would have everything to fear from its union with either of the other departments. Should the court on which I serve resume its encroachment on the legislature under the banner of new federalism, the people can choose to reverse course in future elections, but Wisconsin history shows us the damage is not easily correctable and often stands uncorrected. Wisconsin history illustrates the dangers of a movement that may be misused to transform a court into what Judge Jeffrey Sutton has called a court of outcomes. Thank you.
Thank you very much. Justice Wecht.
Thank you, Judge Bia. It's a pleasure to be here. I was mentioning to my fellow panelists before the session started that I recall 30 or 35 years ago attending a few of these National Lawyers Conventions when I was a lawyer at a firm down the street. I lived up the street and worked at a firm down the street, and I'd stop here and attend some of the sessions, and the crowd was a lot smaller then. But the discussion was just as delightful then as it is now, and I'm very pleased to be here with all of you. I'm also pleased to hear from Justice Young that the Yale Law School was very similar when he attended than it was when I attended, and the state courts were kind of an afterthought. Here we are. So, as you all probably know, the spark, or one of the sparks for the new judicial federalism, was a speech that Justice William Brennan gave at the Harvard Law School in 1977, and it became a very influential law review article. And my colleagues have mentioned Judge Jeffrey Sutton's books, which have really developed this area of law quite thoroughly and quite well. And I guess one way to approach this subject is to note, and of course this is consistent with the preamble to the Constitution, with the 9th and 10th Amendments, that the states and the people themselves, of course, preceded the federal union. And in Pennsylvania's case, our Constitution is significantly older than the U.S. Constitution. Our first Constitution was adopted in 1776, the same year of our independence as a nation, and in the same building, Independence Hall in Philadelphia, which some of you have toured, no doubt. One of the authors of Pennsylvania's Constitution was Benjamin Franklin. And we, on the Pennsylvania Supreme Court, have had occasion to note that our Constitution is the ancestor, not the descendant, of the United States Constitution. Indeed, along with Massachusetts and Virginia's constitutions, the Pennsylvania Constitution played an important role in the thinking of Madison and others as they approached the drafting and debates around the Constitution of the United States of America and its ratification. Now, we can go back to 1932, and I'm sure you all remember Brandeis's words from the New State Ice Company versus Liebman case, that it is one of the happy incidents of the federal system that a single courageous state may, if its citizens choose, serve as a laboratory. And of course, this is the beauty of our federalism and the idea that the various states in our union experiment, and we all learn from these experiences and hopefully gain in wisdom as time goes on. At least that's the idea. The Pennsylvania experience is one that evolved not long after the Burger Court signaled that there would be some retrenchment from the Warren Court, and that there grew correspondingly an interest in many of the states in exploring whether certain protections would be found under their state constitutions. And of course, we rely on lawyers, and I understand the litigation section of the Federalist Society is involved in this, or sponsoring this session, and I'd be remiss if I didn't mention now, because I might forget at the conclusion of my remarks, to urge you litigators to raise these claims, because I'm sure my colleagues could agree, and I can certainly tell you, that there are many, many, many instances in which, and this is very consistent with that Yale Law School mentality. We're beating up on our alma mater here. Professor Amar is here. He's going to rise to the defense of our alma mater. That litigants forego and just miss raising and even invoking state constitutional provisions, which might, if developed properly, be found to afford greater protections. But if the claims aren't made, of course, we can't develop those claims for the litigants, and we don't. But there have been innumerable cases in my time on the court when a colorable state constitutional claim was not made. And I think that's simply a frequent default of people to think only of the U.S. Constitution, notwithstanding the efforts of Brennan and Sutton and so many others to flag this this principle of state constitutionalism, of course, which is very much in line with the philosophy of this society based on federalism. Now, to give you just a very brief tour of illustrative cases, I just want to mention 4 in Pennsylvania. We could talk about them in greater detail if you like or not. In 1991, during that Burger retrenchment, a case reached the Pennsylvania Supreme Court, Commonwealth versus Edmunds. We're one of the Commonwealths. In the Edmunds case, long story short, the Supreme Court of Pennsylvania interpreted the cognate or correlate provision, the similar provision on warrantless searches, Article 1, Section 8 of our Constitution, which corresponds in large measure to the Fourth Amendment to our United States Constitution. And the court declined to adopt Leon's good faith exception to the exclusionary rule. And there were several other states that had also, or had then or have since, followed Pennsylvania's opting out from the good faith exception to the exclusionary rule. And that was premised in part on the court's judgment that based on the history, the text and history of Pennsylvania's provision, that it's based on a privacy rationale rather than a police misconduct prevention rationale. So Edmunds provides the framework for analyzing or comparing when the claim is raised, whether the Pennsylvania Supreme Court should find some divergence or greater rights under its charter than the federal charter. 3 illustrative cases during my tenure on the Pennsylvania Supreme Court, which I'll touch on briefly. And they involve different provisions of Pennsylvania's Constitution. In this case, unlike the Edmunds case, none of which have a cognate or correlate in the U.S. Constitution. I emphasize that. First, the Pennsylvania, and these are in your materials, I believe these are all in your materials if you want to read them in detail. The Pennsylvania Environmental Defense Foundation case 2017, interpreting a provision of the Pennsylvania Constitution which reads as follows, and this is in Pennsylvania's Declaration of Rights. Obviously, this was added long after 1776, but adopted in 1971 by the people of Pennsylvania, and it reads, listen to this language because it will strike you as being unlike anything in the U.S. Constitution. Quote, "The people have a right to clean air, pure water, and to the preservation of the natural, scenic, historic, and aesthetic values of the environment. Pennsylvania's public natural resources are the common property of all the people, including generations yet to come. As trustee of these resources, the Commonwealth shall conserve and maintain them for the benefit of all the people." Time doesn't permit me to go into all the aspects of this, but obviously there's a public trust created there, and the Commonwealth, the state government, is the trustee protecting those environmental rights. Hawaii has a similar provision, and since Pennsylvania's was adopted, some other states have adopted similar provisions. We held in the case I mentioned, Environmental Defense Foundation, that it does not require legislation to be enforceable. Prior cases had held that there was no right of action to enforce it, that it was not self-actualizing, that the legislature had to, in effect, provide an enforcement mechanism. We held that that was incorrect and reversed that precedent. The second one, William Penn School District, I was the author of that majority, 2017, interpreting our thorough and efficient public education. That was my reminder to shut up. I'll be quick. I did that to try to respect the limits, which I'll now disrespect a little bit. Just real quickly, William Penn School District, going back to 1682, William Penn's framework of government for Pennsylvania set out that the people should spare no cost in providing for education, and in fact, that was codified as a thorough and efficient public education responsibility in our General Assembly. we held in the William Penn School District case that was justiciable, reversing a case called Moderator, which has said it's not justiciable, that it's a political question. And we sent that back for trial, and that trial did happen and resulted in an order for the General Assembly to provide adequate funding for public education. Finally, in the League of Women Voters case, which some of you have read about, we took a petition challenging the legislative districting, alleging the congressional districts were politically gerrymandered, and under Pennsylvania's Free and Equal Elections Clause, which has no cognate in the U.S. Constitution, that claims for political gerrymandering, packing, cracking, dilution of votes are justiciable. A year later, in Rucho versus Common Cause, SCOTUS said there is no tool, there is no yardstick by a 5-4 margin for claims under the U.S. Constitution, but specifically cited our decision and said that relief may be available under the state constitutions. And in fact, as I said, we had held in 2018 in the League of Women Voters case that such claims are cognizable. So again, that's just some highlights from Pennsylvania, and I would urge you as lawyers, when you're representing your clients zealously, whether in a civil or a criminal case, to think about and consult your own state constitution, and you may be a pioneer of developing some case law interpreting your own state's organic charter. Thank you.
Thank you very much. I want to take advantage of my position as a moderator to supplement some of what you've heard from the states by telling you about a case that I made mention of earlier that will illustrate to you what the court is doing as far as remanding cases for state adjudication. The case involves a painting, a very famous painting by a 19th century French impressionist, Camille Pissarro, that was owned by a Jewish family in Berlin in 1939 and was stolen from them by the Nazi government. The painting disappeared for years and was finally sold by a count in Austria, Count Thyssen-Bornemisza, to the Spanish government and went into a museum in Spain. When it happened to go in the museum, the family that had owned the painting learned about the painting's existence. They thought it was lost. And they brought claims against the Spanish Museum to have the painting returned to them in the Central District Court in California. The case proceeded through several appeals, and finally the decision of the Ninth Circuit was that the law of Spain, which allowed, in effect, adverse possession if the painting were held openly, notoriously, and as ownership by the museum for a period of years, the title would, by adverse possession, be in the Spanish Museum rather than in the family of the Jewish family that had owned the painting. That decision was appealed to the Supreme Court of the United States. The Supreme Court, Justice Kagan writing, said that the case, the jurisdiction for the case was under the Foreign Sovereign Immunities Act, and since the museum was holding a painting which had been expropriated, the immunity didn't apply. So therefore, the action in the district court in Los Angeles was similar to a diversity action, and therefore the question of which law applied, the choice of law, whether California law, which would vest the painting in the family, or Spanish law, which would vest the painting in the museum, applied, that should be determined according to California law, not federal law, not the restatement of conflict of laws, but California law, which is quite unique. So the case came back to us. The panel decided, a split panel, decided to certify the question to the California Supreme Court. What is the California choice of law rule as to this situation? And one of the reasons that given by the advocate for the family for asking for certification of that question was that he said, quite frankly, he said, we'll be better off in the California Supreme Court than you are here in the Ninth Circuit. So the case was certified to the California Supreme Court, and in August of this year, much to the surprise of a lot of us, the California Supreme Court denied certification 6-1. So the case has come back to us now and is under submission. But this is a case, this opens up the whole question of certification. What has been your experience, Justices Young and Bradley and Wecht, with certification of questions by federal courts to your courts?
We get them all the time, and our court has not refused a certified question for 30 years or more. And in part, that's because the last time it happened, I think that it was regarded as an example of the Fifth Circuit saying, well, look, if we're going to have these cases involving Texas law, we think it's respectful to the Supreme Court of Texas to give you the opportunity to resolve a recurring issue that seems often to come up. And there are questions like that. There are questions of state law. The Uniform Fraudulent Transfer Act often will have these questions that seem to only arise in cases that have the federal courts have jurisdiction over them. Somehow they are always removed, for example. And so to not have to constantly guess, but to get an answer is a way of maximizing cooperative federalism. And so when the court apparently, this is way before my time, refused, it seemed like that was an affront to the Fifth Circuit. Well, fine, if you don't want, we'll just do our own, and maybe we'll never certify anything again. And so, for whatever reason, that custom in our state has taken hold. But it's not just California. The Fifth Circuit. I notice I get the emails every day from the Fifth Circuit, and they within the past year, I think, certified something to Louisiana Supreme Court, which also said pound sand. Mm-hmm. That's not the way we do it. In fact, in our state, when we get a certified question, we not only will answer it, we set it for oral argument. We all go out onto the bench. So that takes up some precious space because we're only going to have 65 or 70 oral arguments a year. And if the circuit gives us something, we take it. And that does lead to a little bit of a conceptual problem sometimes. If the party that really wants the certification was the party that removed the case maybe from state court into federal court, then loses, and wait, let's get the Supreme Court to answer the question. It might not have been something we would have granted the petition for review. We grant very few of them. We have 1,000, 1,300, 1,400 cases that come, and so it can be a bit of an end run. We haven't really thought too much about whether we should modify our practice or not, but by and large, it's a lawful advisory opinion that our people had to change our Constitution to authorize because it is just advice to the circuit. They are the ones that are going to decide the case, but it's a way of ensuring that the law is uniform in both court systems within our state. So we tend to think that we should do it.
How about you, Justice Bradley?
Since I exceeded my time limit in my opening remarks, I'll be rather brief on this one. We regularly will accept certification from a federal court as a matter of comity, and also it makes a lot of sense, of course, for the state's highest court to resolve an issue of state law. The only situation that I can envision where our court might decline certification is if we're sitting 6, and after a preliminary discussion, it appears the court could split.
Justice Wecht?
Yes, we similarly, we have in the time that I've been on the court, we have not ever declined a petition for certification, although I thought I turned that off, sorry.
You didn't give yourself very much time.
Yeah, that was, boy, I think the Federalist Society cut me off there. No, interestingly, I'm told that in the years, I was elected in 2015 to this court, and I'm told that in the years prior, the court had from time to time said no, which is really striking to me, I don't know about to you, as a matter of comedy. it seems elementary that the Supreme Court of a state would grant certification, there being little to no chance that a U.S. Court of Appeals is going to certify something, that's absurd or, something it's given no thought to. In fact, when we get a certified question from one of the U.S. Courts of Appeals, invariably there's a writing that accompanies it, developing for us, even prior to the briefs of the parties, obviously, what it is they're looking to have answered, rather than just a sentence. There's a lengthier writing, at least a couple of pages, it seems to me always. The other thing is, it seems, even apart from comedy, it seems completely counterproductive and self-defeating to say no, because why would any state Supreme Court want the U.S. District Courts and the U.S. Courts of Appeals to be making mistakes about what the state law means, for lack of a better phrasing? We had perhaps during the era when the Pennsylvania Supreme Court would say no from time to certification, there were many, or there were at least several, district court decisions in Pennsylvania, U.S. District Court, and I think maybe Third Circuit too, that had made a prediction about whether Pennsylvania would follow the second or third restatement of torts, and the predictions were that, yeah, we'd follow the third restatement, and when the Pennsylvania Supreme Court, before I was on it, finally got around to deciding that issue, it said, no, it's the second restatement. And so had the court granted certification, probably a lot of wasted time and resources by federal judges and all the litigants and lawyers in those courts would have been avoided. So I don't see any reason. In fact, we have an argument session the week after Thanksgiving, and we have a certified case from the Third Circuit that we'll be hearing that week. And we've heard certified questions from other circuits too, although, most commonly, obviously, it's the Third Circuit.
Is there have any of you on the question of certification considered that the loser in the federal court who asks for certification to the state court might be engaging in forum shopping?
It occurred to me as an advocate when it happened to me, when I won in the Fifth Circuit, and then they said, oh, hey, it'll go to the Texas Supreme Court. So I had to argue it in that court and won it there too. But yes, it is something that is a risk. And so by and large, I think that our thought is, well, the circuit is the one that's going to have to figure out and protect its own integrity. And if it decides, based on all of the factors, that it needs the answer from the state Supreme Court, there's at least a strong presumption that we'll do that. We only will to take it from appellate courts. There are a lot of states that will take certification even from district courts. I don't think we could possibly do that, just given the size
How
of the
about you
state.
two?
We only take it from the circuit.
Right.
Yeah, and that's what they want to do. I'm not aware of I'm not aware of any. Well, let me say this: the Third Circuit takes those themselves. They don't let the district courts, as far as I know, certify. I'm not sure about other circuits, but I've never seen a certification request from a U.S. District Court to our court.
All right. Well, we've heard about a lot about original public meaning here. That's the basis of this whole convention. Tell me, how are the Supreme Courts of these three states dealing with the issue of original public meaning versus original intent versus a living constitution? Is that a subject matter which is going on, a discussion which is going on these days?
Well, yeah, I guess it probably varies from state to state, court to court. In Texas, it is not a formal doctrine, but I think that most of my colleagues will say if we can get what the original public meaning was, that's the gold standard. The problem is, how do you do that in a lot of things? And it's, as I mentioned earlier, it's really hard with a lot of the various things that have happened and changed and been modified a little bit this, that way. When we had our Constitution, we're the 1876 Constitution, you're the 1776, we're the 1876 Constitution, amended about 1,000 times since then, but when the bulk of the work was being done, a vote was taken about whether they should spend a couple of dollars to have a court reporter take down the notes of the convention, and we Texans, we're pretty careful with our money. Well, why would we waste that couple dollars for that? That's a terrible use of the people's money. So we lost access to all of that. So it's hard. In theory, yes, we want to do the original public meaning, but finding out what it is sometimes much more challenging than you would think, and so we're turning to lots of sources to try to get as much data as we can before we mistakenly say, here's what the Constitution means, only to then be proven wrong and then have to have a stare decisis fight on our hands.
What are you doing in Wisconsin, Judge Bradley?
We were doing originalism, but I think that is at its end with the new composition of the court. And there has been a lot of writings, concurrences, dissents, and sometimes in the majority opinions where the debate between living constitutionalism and originalism has manifested. And during my tenure on the court, which has been 8 years, originalism has usually won out, although as the members of this audience will appreciate, there are debates among the originalists about original public meaning, depending on the provisions that we're looking at. Of course, we have much more richly developed originalist sources, and I think the state Supreme Courts are happy when the federal judges will write concurrences if it isn't in a majority opinion on particular issues, because at least in Wisconsin, we are much more resource constrained than our federal friends on the judiciary are. I, for example, have 2 clerks. So the research, we often do look to what the federal courts have done and have written, at least as a starting point if we're looking at issues of federal law. With respect to state constitutional originalism, of course, that is a much more difficult endeavor because of limited sources. I have one. It's an analysis and exposition of the Constitution of the state of Wisconsin. It's a slim volume. This is the original Constitution written shortly thereafter. And our Constitution has not been amended thousands of times, but at least about 150 times. So the more modern amendments or additions to the Constitution, there might be more resources available. But it's a heavy lift sometimes to get attorneys, particularly those serving in the public sector from our state attorney general's office or public defender's offices. They're resource constrained as well, and it's a very time intensive endeavor to do it correctly. But we have at times, again, in separate writings, urged attorneys to present the state constitutional argument to us if they have arguments to be made under the federal and the state constitution. But like my friends in other states, we have some very unique constitutional provisions in Wisconsin that do not parrot the federal counterparts, and that is certainly an avenue for litigants to have a way of prevailing in their cases, but of course that has to be presented correctly, and the research has to be done thoroughly in order to ensure that the justices get it right.
Dave?
I just heard a podcast. Of course, the best one is Professor Amar's America's Constitution. That's the best podcast. I heard a podcast just recently by the National Constitution Center, which has a great podcast. It was a discussion between Professor Sunstein and I think Professor McConnell on this very issue. And one of them, I'm sure Professor Amar's read it, has a recent article addressing all the various, trying to do a taxonomy, actually, of all the various species of originalism, textualism, hybrid theories, living constitutionalism, et cetera. And it's, of course, as you can all appreciate, far more than a dichotomy. There are, many, depending on how you define the various idiosyncrasies of different jurists' approaches. You have, even on our current Supreme Court of the United States, there are different species of originalists and textualists, what have you. I guess it was Justice Kagan who wrote not too long ago, we're all textualists now, right? So The text obviously is the beginning. Often it's not the end, and that's where a lot of the debate arises, of course. I'll just add one more thing. In Pennsylvania, under our Constitution, we never abandoned, the people of Pennsylvania never abandoned the Jacksonian impulse. So we still elect all of our judges at all levels, and we just concluded, the people just elected a justice on Tuesday. And very much from what I read in the news, the two candidates were debating this issue, among others, how they approach interpreting the Constitution, statutes, and this debate about originalism, textualism, and living constitutionalism was, of course, at the forefront, though probably not discussed at the same level of eloquence and academic sophistication as Professor Sunstein and McConnell or Professor Amar. But I mean, it's funny you asked the question because we were just seeing, the candidates speaking about this this debate in Pennsylvania.
Okay. The next section of this chat, this presentation, is opening up to the participants any questions that they may want to ask other members of the panel or to talk about generally, and then we'll go to questions from the public.
Well, Justice Bradley just mentioned something. There are provisions of the Wisconsin Constitution that don't parrot the federal Constitution, and I mentioned that we have some that seem to and some that don't, but let's assume for a second that it's one that does. It's word for word the same as the U.S. Constitution. Well, that sounds like now we know the answer, but I'm not sure that that's quite right. Because if 150 years ago the people of Pennsylvania, Wisconsin, or Texas enacted a provision that's word for word what the U.S. Constitution was at that time, well, does that mean that all we have to do is to look and see what the U.S. Supreme Court 150 years later says that it means? Or is that a command by the people of our state for their judges in their state to accurately say what they think the U.S. Constitution meant, regardless of what the U.S. Supreme Court says? It's a very tricky little dilemma, and it opens up a whole new universe, even when it seems like it's the easiest question. Thank goodness, this is just the same contracts clause as the federal Constitution has. We can go home. Well, not so fast. And that's a real problem that we have not really begun deeply to grapple with, but I'm afraid we're going to have to.
I think, Justice, you've identified a very interesting issue, because in that Edmonds case I mentioned in 1991, unlike the three cases I mentioned that we've decided since I've been on the court, in that case there was a very, not identical, but a provision that was very similar, but the court, the 1991 Supreme Court of Pennsylvania, nonetheless arrived at a different, and by looking not only at the text but at the history of the Pennsylvania provision, because we have records, going back in Pennsylvania, the related case law from other states, and policy considerations unique in Pennsylvania's experience, including unique issues of state and local concern and applicability within modern Pennsylvania jurisprudence, a four-part test. So when there are, unlike these three cases, cognate or correlate provisions, the Pennsylvania Supreme Court applies this Edmonds rubric to determine whether we depart or not. And in our case, many of our provisions precede the U.S. Constitution's provisions. But I think you've identified an interesting issue, because at least from what I understand from our precedent, we have an independent duty to interpret our own state constitution. And if we are persuaded by SCOTUS's rationale, we can adopt it, but we don't rubber stamp it in any sense. Okay. Even if in theory it's identical.
And in Wisconsin, the court has, I think, very reflexively interpreted counterpart provisions of the Wisconsin Constitution consistent with how the federal courts have interpreted the federal Constitution counterpart, particularly when the language is nearly identical. And I don't believe that that is the proper course, but there has to be the historical evidence to support a contrary interpretation. I think the lockstepping has happened over a long course of time because, for one, it's easier, right? Again, in the state court system, we tend to be more resource constrained than the federal judges are. And secondly, if there aren't resources available, and until the advent of computers, and even then, it's still difficult to do the research. It's very difficult, very time intensive to uncover the historical evidence that would support an interpretation that departs from how the federal counterpart is interpreted. Wisconsin's Constitution, unlike Pennsylvania's, at least originally, is from the 1800s, mid-1800s, and so I think there is just a natural tendency to go back and look at, well, the language isn't any different, so we're going to follow what the federal courts have said. But I don't think that should be done reflexively. But again, the evidence has to support a different interpretation. And we do not in Wisconsin, at least for now, introduce the policy considerations that I think are part of Pennsylvania's test, as I've read the Commonwealth v. Edmonds case that Justice Wecht has talked about.
If there are no other questions that the panelists want to kick around among themselves, we'll turn to the public and ask your first question. Please identify yourself and then ask a question.
Good afternoon. My name is Nick DiBenedetto with the Pacific Legal Foundation. Question I have for the justices is thinking about a situation where you're trying to do two tracks of originalism at the same time, and how you might think about a situation that you could call like a constitutional leapfrog. And specifically what I mean by that is, famously, many state high courts have rejected the Supreme Court's Kelo decision and have said that the state takings clause is more protective and more robust. How would you think about a situation where the Supreme Court subsequently changes its interpretation of the takings clause to something that is perhaps more originalist and more faithful to the original public meaning? Is it the case that you're necessarily left with a dead provision of your state constitution, or is there something still there to grapple with, maybe with respect to background principles in the common law that might give additional life to the relevant provision of the state constitution?
Who wants to handle that one? Kelo under state law different from Kelo federal law?
I mean, I guess I would say that it's maybe a manifestation of the very thing we were just talking about a little bit, and that is if we were to start off with two choices. One, we're just going to reject that based upon our own Constitution. If we have text and history that justifies that, I don't know that that would make much of a difference what the U.S. Supreme Court were to say. Maybe the U.S. Supreme Court comes to the same conclusion eventually, and they match up. It shouldn't necessarily matter if the clause is different. They're just different sources of the law. They can be more or less protective of each other, and you let the chips fall where they're going to fall. But if it's a situation in which the text is the same, the understanding is, well, we're in lockstep with it, it's a little strange for the Supreme Court of Texas to say, well, our takings clause means the same thing as the federal one. We didn't know until the Supreme Court just said that it meant this, Kelo, whatever you might want to say. Then fast forward 15 years, well, now the Supreme Court says that the federal one doesn't mean that anymore, so the Texas one doesn't mean that either. That's more piggybacking than leapfrogging or anything else, whatever animalian metaphor we want to take. And that's the conceptual problem that we've been talking about, and I think we just have to do our best to use our own text, history. While I think, Justice Bradley, you're quite right to say, maybe there's, I don't want to put words in your mouth either, but I thought I heard something about the idea that maybe if you already have something in similar language and you have something from the Supreme Court, that's maybe not a bad default starting point until you have something else that's really solid to go by. And I'm not super excited about just saying without any strong reason to say it, that similar language in our Constitution means something completely different. I need some reason for it, especially if the federal Constitution has already been given a binding construction. It makes me a little nervous to jump out ahead unless I have a good reason to it. I don't want to jump and not know what's beneath me.
Okay.
If I understand the question correctly, I'd like to think I wouldn't find myself in this conundrum because I would not reflexively, again, follow the United States Supreme Court's interpretation of the federal takings clause when Wisconsin has its own, which is a little bit different textually. So given being presented with the issue, I would undertake the originalist analysis. And I think, Judge Bea, I don't know that I actually answered your question. In Wisconsin, it would not be original intent originalism. It would be original public meaning. I think that has prevailed in Wisconsin as it has in most jurisdictions, because the question shows the absurdity of saying that a state constitutional provision must mean what its counterpart means under the federal constitution, because a federal court or many federal courts have said so, because that fixed meaning cannot change based on changes in what judges say in cases. That's nonsensical.
Dave?
Yeah, I agree with my colleagues, and I think your question underscores the need to drill down and do a state constitution analysis, because if SCOTUS reverses itself and all that the state has done is parrot SCOTUS, then query whether, without further analysis, the court in the next case simply says what they said. So, it just points up the need to do an independent analysis. But again, time and time again, lawyers just blow it off or just phone it in or don't actually raise the state constitutional claim, and it's a foregone opportunity.
Yes. Let's go over here.
Yes, David Ziemer from Wyoming, but originally from Wisconsin. And Justice Bradley, there is one time that the Wisconsin Supreme Court did do that. I mean, and this was before you were on the court, and this was after Butler was long gone, or yeah. But if the U.S. Supreme Court had held that a jury does not need to have 12 people, but the Wisconsin Supreme Court said that under the Wisconsin Constitution, there must be 12. And what their reasoning was that by the time our Constitution was adopted in 1840, whatever, a jury meant 12 people. That was just common understanding. And like I said, that's the only time I've ever known the Wisconsin Supreme Court to do anything like that. But I was wondering if any of you guys, and I don't remember how well it was reasoned or anything, or what they all looked at, but I was just wondering if that's something that either of you dealt with in a different context.
I don't think so.
Any comment on that?
I can't think of anything off my head that would be helpful.
I can't either.
I can't comment on the reasoning. I'd have to go back and look at it.
All right, back over here.
Akil Amar, Yale Law School. I want to ask a question about originalism, precedent, reliance, and criminal procedure. So it's going to be more probably for Justices Wecht and Bradley, given that Justice Young sits on a court that mainly
Could you
has
speak up a little bit? I can't hear you.
civil jurisdiction. Question about the relationship between criminal procedure, precedent, reliance, and originalism. Justice Bradley, I heard you say that we heard about two cases, one about excluding fruits of a Miranda violation, contra Patain, and Justice Wecht talked about the Edmonds case, which is about the good faith exception to the exclusionary rule more generally. Has any prosecutor ever made the following thing? Because it's not just private litigants. Look, there shouldn't be a ratchet at all here, because as a matter of originalism, for the first 100 years after the founding, no court ever excluded evidence just because it was improperly obtained, state or federal. And so Edmonds is wrong, actually, as a matter of the original meaning of the Pennsylvania Constitution, which some of us have studied. And that Wisconsin case was wrong to reject Patain. Yeah, you can say, and conservatives, has any prosecutor ever say, yeah, there's precedent, but there's no reliance here? Because people actually don't legitimately rely, oh, if I had known that there wouldn't be this exception to the exclusionary rule, I would have never committed that murder, that rape, that robbery. Oh, I would have been much more careful about, hiding the blood on the clothing. Have prosecutors, because it seems to me that precedent is rooted in rule of law values, which are connected to reliance and the rest, has any prosecutor actually said, no, there shouldn't be the ratchet at all in criminal procedure? Because I heard Justice Bradley say that's actually what some of the conservatives worried about, and so you never overruled those, that Patain case, and same question about the Edmonds case.
Well, I would just say that I am looking forward to reading your amicus brief, Professor Amar, arguing for the reversal of Edmonds, and I will read it closely and consider it. Of course, that's I remember, was it Chief Justice Roberts at his confirmation hearing when he talked about a super duper precedent, or was it somebody else? I guess Edmonds would be as close to that in the Pennsylvania setting as most precedents, as probably any other precedent. But I take your point, and certainly the court should always be willing to entertain arguments that its precedent is wrong. And I often rail against precedent that I think is awful. I'm reminded of that time. Maybe some of you were there. Maybe it was a Federalist Society event where Justice Scalia and Justice Thomas were sitting on a panel, and there was a question asked about precedent, and Justice Scalia pointed at Justice Thomas and says, "That's easy. He doesn't believe in it." So, I'm, for my part, I'm very willing to. I suppose I'm more willing than many to overrule precedent, notwithstanding asserted reliance interests, although I don't minimize them.
Anybody else want to comment on that?
Well, I can respond by saying, to my knowledge, no prosecutor has made that argument, because I don't think there were ever 4 votes on the Wisconsin Supreme Court to go back to original meaning in the manner that you suggest, so it would be a losing argument. And I think a lot of conservative jurists who might otherwise either subscribe to originalism or be open to it would say, well, that ship has sailed, and so we're not going to go there. But no prosecutor, to my knowledge, has made that argument in Wisconsin.
I would just say that a prosecutor in Pennsylvania who wanted to revisit Edmonds and say Pennsylvania should have the good faith exception to the exclusionary rule should definitely cite your work and should get you on an amicus brief. I would look forward to reading it.
Thank you, Your Honors.
Thank you, Professor.
Do you want to weigh in on
But he mostly directed it to my 2 colleagues because he knows that the people of Texas have given me one of the greatest gifts imaginable, which is to say that I have no jurisdiction over adult criminal cases. We have juvenile criminal cases, and we occasionally have some collateral things from it. But think about the luxury that gives a judge on the Supreme Court of a big state. The amount of time that some of my colleagues have to spend, can't get to a lot of the important civil cases. That's pretty much what we do, is the civil stuff. But I would say that I'm not sure that the analytical points you made are all that different. I wrote a stare decisis case in my first year on the bench, and tomorrow will just be the anniversary of my 2nd year, so I'm still the newest one on this panel or on my court. And it was about a procedural issue involving whether when there's a severance of cases and you accidentally file something in the old one, and then the jurisdiction of the court expires and that's the end. Well, nobody acts in reliance on that, just like they don't act in reliance on the exclusionary rule and they decide to commit some heinous crime. And so when you're thinking about whether stare decisis applies, I think that mode of operation is really important in any legal context.
Thank you.
All right, next question over here.
Anthony Sanders, Institute for Justice. I have a question about the flip side, kind of the lockstep problem you were discussing. So many state constitutions have these provisions at the beginning of their declarations of rights called, that Steve Calabresi calls Lockean natural rights guarantees, that have these broad language protecting property and liberty and the pursuit of happiness even. And 2 of those states are Wisconsin and Pennsylvania. And many state Supreme Courts, including Wisconsin and Pennsylvania, have interpreted these provisions to basically be due process clauses, even though they do not contain the words due process. And so, and then they couple that even with the U.S. Supreme Court, what it has said about the due process clause in the 14th Amendment. So is that a problem? And what can we do about it?
Well, I would just say that I've written several, I guess, concurrences and dissents railing about, and citing Professor Amar, by the way, on the oxymoronic nature of substantive due process, and calling for SCOTUS, and failing SCOTUS, then other state and federal courts to develop a jurisprudence under the Ninth Amendment, which is still anemic, hasn't developed since my constitutional law professor, Charles Black, wrote on, what was that book called, that thin book, Professor Amar, on reading the Ninth Amendment? Anyway, it's died on the vine. And of course, since the Slaughterhouse cases in 1873, privileges or immunities have never been developed. And in the federal context, the Ninth Amendment and the Privileges or Immunities Clause, I think, ought to be doing a lot of the work that has been crammed into this substantive due process construct that has become increasingly problematic as it gets examined over time. I would say that you're exactly right, that Pennsylvania has entrenched in its first article of its Constitution and in the preamble a Declaration of Rights. So there's a substantive component right in Pennsylvania's Constitution that is quite lacking under the U.S. Constitution. Again, unless you're finding it in the Ninth Amendment or the Privileges or Immunities Clause or substantive due process. But we've got the substance in our Declaration of Rights. At least we've got substance that you don't find in the U.S. Constitution. Lockean.
I've actually written on this. Unfortunately, I was in dissent. It was co-authored with Justice Daniel Kelly, who is then on the court. I think he might be in the audience, but the glare from the lights precludes me from identifying him in the audience. But the case is called Porter v. Wisconsin. And the individual was challenging the constitutionality of an anti-combination statute. He owned a cemetery and wanted to operate a funeral home, and there's a piece of rather protectionist legislation in Wisconsin that precludes that sort of dual ownership. And one of the arguments that we were presented with is whether there's a right to economic liberty under the Inherent Rights Declaration of Rights, which is Article 1, Section 1 of the Wisconsin Constitution, which, as you note, as is the case in many other jurisdictions, has been interpreted to mean something procedural and not a source of substantive rights. So we looked back at cases shortly after ratification of the Constitution to find out what was meant by the Liberty Clause, particularly within the context of economic liberty. And in some very early cases, and I mean early, a decade or 2 decades after, and in some cases several decades after statehood, the Wisconsin Supreme Court did recognize a right to earn a living as one of the great bulwarks of individual freedom guarded by fundamental law. The court also said that laws interfering with the right of the citizen to pursue his calling, which invade the right of the citizen to pursue a lawful business, cannot be upheld. And in these early cases, the court declared unconstitutional laws that prohibited, in one case, plumbers from engaging in the plumbing business as a solo plumber. They had to be in partnership with other plumbers. So the early cases said that the general right of every person to pursue any calling and to do so in his own way, provided he doesn't encroach on the rights of others, cannot be taken away by legislative enactment. So again, unfortunately, these are separate writings. It has not prevailed as the majority view because, again, the majority of my court has tended to adhere to stare decisis even when the look back into original meaning shows that their early decisions are and were incorrect.
Evan?
I don't have anything further to add.
Okay. Next question over here.
Arif Punji with the Institute for Justice, and I assure you we are not engaging in federal lockstepping with my colleague Anthony Sanders. But my question is about federal lockstepping and the importance of, in looking at original public meaning of state constitutions, the importance of the structure of a state constitution. We all know that enumerated powers are how the US Constitution opens up, but usually a state constitution opens up with very robust restrictions on power, the very opposite. And I wonder, when looking at the original public meaning, is the very structure of a state constitution, the fact that it front loads protections for liberty and constrains power right out of the gate, enough to reject federal lockstepping and the watered down tests and deference that comes along with that, and instead have a more pro-liberty, more engaged from a judiciary standpoint jurisprudence, because the ratifiers ratified something very different than the US Constitution structurally. So the question is about structure.
I would just say, I think you're right. And you folks file really good briefs, by the way. I haven't always agreed with you. You haven't always agreed with me, but I think your briefs are always interesting. Pennsylvania's Constitution begins, Article 1, Section 1 is titled The Inherent Rights of Mankind. And it says, all men are born equally free and independent and have certain inherent and indefeasible rights, among which are those of enjoying and defending life and liberty, of acquiring, possessing, and protecting property and reputation, and of pursuing their own happiness, right? So structurally, obviously you see from that, that sounds a lot more like the Declaration of Independence, or at least the way it starts, than it does the U.S. Constitution, which is not a happenstance or coincidence, right? Because I told you, it was drafted in the same building in the same year as the Declaration of Independence, and Franklin was perhaps the principal draftsperson. So, yeah, structurally, I think there's a big difference, and textually, there certainly are differences.
Okay.
I agree with that as well. In Wisconsin, as I mentioned, Article 1, Section 1, this is not a preamble. This is the very first provision of our state constitution, says all people are born equally free and independent and have certain inherent rights. Among these are life, liberty, and the pursuit of happiness. And this part is very important. To secure these rights, governments are instituted. And so that's something that I think our branches of government, our elected officials sometimes lose sight of the fact that elected officials are there. Their primary purpose is to secure the rights of the people. And everything else that flows in our Constitution, particularly when we're looking at the powers that the people have given to each branch of government, we have to remember that we exist as government officials to secure the rights of the people. And it ends by saying, to secure these rights, governments are instituted, deriving their just powers from the consent of the governed. And so when any branch of government exceeds its constitutional authority as laid out in this sacred document, they are acting without the consent of the governed. And I think the structural constitution is sometimes missed by litigants, by attorneys who are giving short shrift to the structure of the Constitution, what it means to put a provision like that as the very first provision of a state constitution. I have to say, I don't blame them because of the way that my court and I think other state courts have given this only procedural significance rather than substantive significance. And as a final point, I'll say, again, in giving substantive meaning to a provision like that, it can't just be, well, liberty means everything. It meant something when this Constitution, when this provision was ratified by the people. So the evidence has to be there historically.
I'm sorry we've run out of time. I can't take your last question. I want to thank the panel because I think they've done a great job of stretching our minds as to the importance of state constitutions in litigation. And you'd all be probably guilty of malpractice now if, having heard this panel, you don't read your state constitution before you start drafting your
It'll take a while to read the Texas Constitution, though, so big cup of coffee.
All right. So
Everything's big in Texas.
That's
Everything's
right.
big in Texas.
let's show our thanks to the panelists.
Nice participating with you. I really enjoyed it.
I'm required to read to you the following. If pursuing CLE, make sure to sign out using your CLE QR code. Beginning at 5:15, shuttle buses to the Washington Hilton will leave the Mayflower Hotel every 5 minutes. The pickup is on DeSales Street. The last bus leaves the Mayflower at 6:30. Okay? Thank you very much and see you at dinner. Not at the Union Station.